So make UPSC a dream that won't come in your sleep, but a dream which won't let you sleep. So be motivated for your exam, because that is very, very important. Because if you are not motivated, if you are not like, energetic, so then how you will face such kind of toughest examination, right? Okay. So now here it is, the article. Very beautiful article is here, polity plus governance, like so weighing on a health data retention plan. So privacy centric, as you can see here, it is a privacy centric process is needed to determine what data to retain and for how long. So basically this is for the prelim section, K. Puttuswamy case, article 21, and various dimensions of right to privacy which have been covered in this section. And if you talk about the mains exam, here is right to privacy, article 21, right? So basically this section is important for your exam, for in point of like prelims as well as in mains exam, right? So basically lots of questions has been asked in 2021, the right to privacy. So we will discuss like how we will segregate such questions, like we will discuss like what kind of question can it be framed from the upcoming exam, or is such kind of question has been asked earlier in your exam. So we can say, okay, so here is a question has been asked. So here a question has been asked is, okay, so here this question is right to privacy. This exactly this article is not exactly based on right to privacy, but how it is important. Here it is, right to privacy is protected under which article of the Constitution of India? So basically the question is, right to privacy is protected under which article of Constitution or article of the Constitution of India? And this question recently asked in UPSC 2021. So as we can see, article 15, 19, 21, article 19 is basically like freedom of speech, right? So article 21 is the right answer, because article 21 is talking about basically is right to privacy is through the constructive mechanism. What exactly it is? We will discuss what exactly the constructive mechanism. Like see, so in justice, sorry, so in see, right to privacy is a protected and okay. So we can see it here in Justice K.S. Puttuswamy and Union of India landmark judgment of Supreme Court of India held that right to privacy is protected as a fundamental right under Article 2014, right? 1921 of the Constitution of India. So here it is right under Article 14, 19 and 21. So why the answer was not 19? Because through the constructive mechanism. What exactly is the constructive mechanism? Basically, in this case, as landmark judgment, government is explicitly mentioned that right to privacy is protected as an intrinsic part of the right to life and personal liberty, right? The person have a person is able to freedom of speech, which is enumerated in the article 19, right? So liberty in article 21 as a part of freedom guaranteed by the part 3rd of the Constitution, right? So the correct answer is here C. And what are the sources of the question is here? Sources of the question is basically the question is fundamental right, which is taken from the M. Lakshmikant. As you are very aware about, like M. Lakshmikant is very, very important in terms of prelims and as well as mains examination, right? Okay. While further moving, right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following is Constitution of India correctly and appropriately imply of the above statement? So as you can see this question which has been asked in 2018, right? So Article 14 and the provision under the 42nd Amendment to the Constitution. No, because here we are talking about right to privacy. Article 17 and DPSP, Directive Principle of State Policy. As we can say, the Article 17 basically untouchability, right? So that has to be protected. So Article 17 is comes under Directive Principle of State Policy. So that we cannot say the B is answer. Article 21 and the freedom guaranteed in the part 3rd of the Constitution. Yes. So Article 21. So C is the right answer, because as per the question, here it is right to privacy, right? It is protected as an intrinsic part of right to life and personal liberty, which we have recently discussed. So which of the following is here? C is the right answer. Article 21 and the freedom guaranteed in the part 3rd, right? Okay. While further moving, so basically this question is asked. The Supreme Court ruled that right to privacy is protected as an intrinsic part of right to life and personal liberty. So here is Article 21, we need to keep in mind, because article which is the right to freedom, right to privacy, right to spread the religion. So such kind of question is usually asked in your exam, right? So option C is the right answer. So Article 14 is, what about Article 14? Gives the right to equality, as it is mentioned in the 42nd Constitution Amendment Act 1976, is known as mini constitutions. So which article is known to be mini constitution? So article basically 42nd Constitution Amendment Act is known to be a mini constitution. So this gives the right to equality. Next one is Article 17 is related to the abolition of untouchability. What about the Article 17 is basically is related to the abolition of untouchability. So it comes under, it is a part of right to equality, right? This parts on the right to equality. Right to equality, part 4 is basically Directive Principle of State Policy, does not have any mention about the privacy, right? DPSP is not talking about the privacy, keep in mind. So Directive Principle of State Policy, it does not have any mention about the privacy. Article 24 is basically prohibition of employment of children in factories, etc. So here is comes under which Constitution Amendment Act is basically 44th Constitution Amendment Act. 44th Amendment of the Constitution was enacted by the Janata government, right? Mainly to nullify some of the amendment made by the 42nd Amendment Act 1976. So the time when it has been announced, there was some criticism in that Amendment Act. So that's why it has been changed by 44th Constitution Amendment Act. So once you solve the questions, you just need to try to find it out, the background information, because somehow that is very, very important. Sometimes the question is somehow interlinked with the last previous year, like 2018-17, and they will ask in the other form in the 2021 and as well as upcoming 2020. Okay, so we have discussed the question that was asked in the previous year examination, right? And now here is a mains questions that is based on right to privacy, right? So examine the scope of fundamental rights in the light of latest judgment of the Supreme Court on right to privacy, and that the question was asked in the UPSC mains 2017. That was a 15 markers question. So try to follow that kind of system, like intro, body and conclusion, right? What you have to mention here in the introduction part, as an introduction part, why right to privacy is important, because it's in that time that what was the latest judgment, so you just need to mention it over there. And in introduction part, you have to mention why right to privacy is important. So in every aspect is you have to cover it, why right to privacy is important. And that the second step is that in the light of latest judgment of Supreme Court, so in that time that judgment you need to mention in the body. And the conclusion part, in a very constructive way, you have to be finished in a way that can be like why it is the important segment, right? So once you are going to write answer writing, make sure like you need to follow like intro, body, and as well as conclusion, that things that you will discuss. Okay, now coming to the article. So in a welcome development, the National Health Authority (NHA), the body responsible for administering the Ayushman Bharat Digital Mission. So here is Ayushman Bharat Digital Mission. So here is Ayushman Bharat Digital Mission. So make a short notes on that about exactly the Ayushman Bharat Digital Mission, and that mission that is implemented by the National Health Authority has initiated a consultation process on the retention of health data by healthcare providers in India. Basically, this article is talking about like with the like in the process, like in the health segment, that we collected most of the data from the patient, like, but where is the privacy is important, right, in that segment, because the need for such a policy, the Supreme Court on India has clarified that privacy is a fundamental right. Privacy is a fundamental right, and many interference into the right must pass a four-part test. Like what four-part test? Like legality, legitimate aim, proportionality, and we can say is here appropriate safeguards. So in this segment we can say is here is legality is basically whether that privacy is legal or not. So legitimate aim, it means whether it is a valid for the every parts of the country or not. Like, and proportionality, it means that maximum number of person is getting advantage through this or not. And that next one, the appropriate safeguard, whether this one is getting safeguard to the citizen of India. So in that segment, that SC is clarifies the privacy is a fundamental right. So basically, in short, we can say this article is talking about, like, we can say like, you know, this article is like in a segment ki like the patient जो होता है हमारा patient जो patient doctor के पास जाते हैं, in a very lucid manner I am talking you, like, so that case, that data can be used from somewhere else. So where is our privacy? So in that segment, see, here is the mandatory retention of health data is one such form of interference with the right of privacy. In this context, question of legality becomes a questions about the legal standing and authority of the NHA, which is National Health Authority. So what exactly the balancing benefits and risk in this segment? Okay. The aim of data retention is described in terms of benefit to individual and public at large. So basically, we can say so aim of data retention is described in terms of benefit to the individuals and public at large. So maximum number of citizens will get the benefit. Individuals benefit through greater convenience and choice created through the probability of health records. So basically in this article, like if you talk about like patient consent is very important if you are going to release any data, right? The broader public benefit through research and innovation driven by the availability of more and better data to analyze. So what it has mentioned, the broader public benefits is important through research and innovation driven by the availability of more and better data to analyze. But in particular, privacy risks should made us very hesitant about retaining an individual's entire health on medical record on the ground that they might be useful for research someday. Yeah, that can be used for any diagnosis of a patient, for example, the person is like, for example, suffering from the diarrhea, person is suffering from like COVID-19. So there is some special patient like if occurs, so we can send it to the team that can useful for the research. But what about the citizens' privacy in that regard? Because in the COVID era, once they started in 2020, so initially lockdown, as we can see that most of the person which is in the home isolation, so the big poster has to be imposed on that out in front of your house, or in the inside of the house also, but basically the order of the gate, like that the patient name is this one and the person is suffering from the COVID. So later on, the Delhi High Court has announced that the person right to privacy is violated. So in that regard, we will not follow this one, right? Okay. So what exactly the possible safeguard? What would be the possible safeguard? So the test for the retaining data should be that a clear and specific case has been identified for such retention. Right, following a rigorous process run by suitable authorities. So that authorities will take this data from the patient. A second safeguard would be the anonymized data that is being retained for research purpose, again, unless a specific case is made by keeping personally identification information. Right. So basically informed consent. So basically informed consent must be used. What is informed consent is basically the patient consent. Patient has to be informed that your diagnosis that can be used in the later on for our team. So it has to be the word informed consent. So informed consent, which means we have to be informed to the patient that we are using your data for your further research. If the person is denied, so in that case you will not further proceed this. But matter is if we talk about in a generalized way, whether if you are going for the treatment of any doctor, so how can we go against that doctor or that team, right? So the second safeguard would be the anonymized data that is being retained from research purpose, again, unless a specific case is made for keeping personally identifiable information. And alternate basis for retaining data can be express and informed consent of individual. So here it is mentioned again, informed consent is important. Informed consent is important of the individual in this question.